Chairperson for the session is Dr. Arjun Sundaram. Dr. Arjun is an emergency physician by qualification and training. He is also an independent professional who consults on execution of leading edge projects focused on healthcare. He has a successful track record of 8 years working in Pondicherry. He has worked as a research fellow in the Cleveland Clinic, USA from 2005 to 2007. He has earned much admiration for his thoughts and leadership in the field of healthcare and education. Dr. Arjun is the Secretary for the Society of Emergency Physicians of India Pondicherry Chapter and the previous Vice President of Emergency Physicians of India. I invite Dr. Arjun Sundaram, State Representative Pondicherry Kaho, to chair the session.
A very good afternoon to all. It's my pleasure to introduce Mr. Samuel Abraham. Mr. Samuel Abraham is a practicing advocate by profession. He has worked as an assistant in Directorate of Rural Development, Kurulagam, Madras, and he was an administrative officer in Reliance Motors, Mount Road, Madras. He has also worked as a personal manager in Sharjah Electricity and Water Department, and he served as a manager in Karunya Deemed University in Coimbatore for 12 years. He is currently serving as a senior law officer in Christian Medical College, Vellore, since April 2005. He has also contributed to many books and articles related to labor and consumer laws. He is a rich resource person in various workshops and conferences in healthcare management. It's my pleasure to welcome Mr. Samuel Abraham.
Thank you very much for the introduction. I am so happy to be here in this meeting. Without wasting any time, I am going to touch my subject. Actually, the subject which I am going to talk is entirely different from the subject so far discussed. Slightly different as far as HR is concerned. Now, briefly, I will give the small introduction, then I will go to the subject. In India, we are having various types of law. We call procedure law, beneficial law, personal law, mercantile law, business law. Then we are having so many other categories of law. One of the category we call is procedural law. Indian Penal Code, Criminal Procedure Code, Civil Procedure Code. These are the codes where the procedure is being specified. For example, a code, civil code from Kanyakumari to Kashmir, they are following the same civil procedure code. From Kanyakumari to Kashmir, all criminal codes are run by the criminal procedure code. The code means the parliament or legislature prescribes certain procedures to be followed, which we call code. Now in India, from independence, the parliament has been enacted so many beneficial pieces of legislation for the labor. We call special law. It is applicable only for the labor. The Industrial Dispute Act divides the labor into two, workmen, non-workmen. Workmen, there is a different type of adjudication. Non-workmen, a different type of adjudication. We are having, if the parliament wants to give maternity benefit, they will enact maternity benefit. If they want to give minimum wages, they enact minimum wages. So every now and then, when demands comes, as a piece of legislation, parliament or legislature enact laws. But in Western countries, they don't have such law, they are having code. So in India, with its own wisdom, the parliament enacted 4 labor codes, now codifying all the procedures and merging all the labor laws so far in existence. For example, 45 different type of labor laws are abridged and given as 4 codes. Now, 2019, the labor codes were enacted by the parliament, notified, but it was not implemented because a labor subject comes under a concurrent subject. Both their parliament enacts, but all the states has to implement that law. In other words, even though parliament enacts the law, it will be implemented only by the states. Now we are going to see certain slate. In 2019 it was enacted, but so far the 4 labor codes are not implemented because being a concurrent subject, the states has to frame rules and regulation. After framing rules and regulations, it will be implemented. For your knowledge, I am telling, different labor codes, out of the 4 labor codes, different labor codes were notified by different state governments, but the central government wants to implement it from 1st April 2023 for whole India. For your knowledge, I am telling, the 4 labor codes are implemented by the central government for its employees and its organization, plus its union territories now. But they were not implemented in any of the states in India because they are waiting patiently that the states will frame rules and regulations because they are the people who implement the 4 labor codes. So, to my knowledge, latest from 1st April 2023, the 4 labor codes will be notified and the rules will be implemented all over India. Now, out of the 4 codes, only 1 code we are going to see that. Now, before that, I will give a preliminary explanation about this code on wages. Now, code on wages replaces a few labor laws now. 4 labor codes, these are the code on wages. 24 states have framed rules now. Social Security Code, 18 states have framed rules now. Occupational safety, health and working conditions, these 13 states have framed rules. Industrial relations, 20 states have framed rules to implement this. This industrial relations is the word which is being used in the United States, and a long time it's a pending because many of the people, they have said, why we are having Industrial Dispute Act. The act itself says it's an industrial dispute. So, in that place, now we are following Industrial Relations Code. Now, out of the 4 codes, there are many changes which HR managers has to understand and implement. There are many good things, a few things which are not so good for some people. Now, before going to the exact subject, I will go quickly. What is happening here? Minimum Wages Act. This code also codifies Minimum Wages Act. Now, Minimum Wage Act is being implemented by the state governments. The minimum wage is fixed for class of employers only, not all. Few class of employers has to follow Minimum Wages Act, and the class of employees will be notified by the state government. And these will be categorized into 3 categories: corporation area, municipality area, and village panchayat. So different salary, different allowance are fixed under Minimum Wages Act. And once in 4 years or once in 5 years, they will constitute a committee to study the cost of living. Then it will suggest some ways and means to revise the minimum wages, and then it will be implemented. From 1st April every year, listen to me, 1st April every year, the state government will notify the minimum wages to be followed in that year. Normally, after 5 years, a committee will look into the matter and they will revise the whole salary. But this is for a certain class of employers, formally 50 or 55 type of employers only. But the labor code now says wage code is being implemented to all the employers which we are going to see. That's why I want to give an introduction. The purpose is to consolidate and amend the laws relative to wages and bonus and matters connected therewith and incidental thereto. Now, listen to me, this is very important. Code of wages codifies the following act: Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, the Equal Remuneration Act. These are all brought into one code. These are the chapters: preliminary, minimum wages chapter, payment of wages, payment of bonus, advisory board, payment of dues, how the dues to be paid to the employee will be collected. These are one chapter. Inspector, now the inspector of labor is designated as a facilitator. The jargon is different now, and offences and penalties. Now, who is employee? The code defines every person. Here you can see, other than the apprentice, employed on wages by an establishment to do any skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, all the people now defined as employees. Now, as on date, as a lawyer, I am telling you, there are 44 types of labor law. It gives different type of definition in every different type. Now it has been amalgamated and given one definition. Employee includes all. Apprentice, who is not a worker, is also clearly defined. Now, this is the portion I would request all the HR managers to listen very carefully. So far, normally for statutory calculation, basic and allowance will be taken for gratuity and each and everything. We will say basic and DA. Normally we will take it as a wage. All other allowances differ from employer to employer. So normally for wages calculation, statutory benefits, basic and DA. So many employers will put a very lowest grade as a basic. So that payment of statutory benefits will be less. And they will increase the allowance, various type of allowance, with a different type of name. Now, this code is very, very tough in that matter. Now, listen to me, then only you can listen, you can catch this. Wages means all remuneration includes basic pay, DNS allowance, retaining allowance if any, all other allowances which I am going to describe. Bonus is not included. Now listen here, if an employee is fixing the basic wage very low and DA also very low, but he is giving various type of allowances, there is a check here. Now if payments made by the employer to the employee under class A to I exceeds one half or such other percent as may be notified by the central government, the amount which exceeds such one half or the percentage so notified shall be deemed as remuneration and shall be accordingly added with the wages. So, if you are fixing the basic and allowance very less and you are adding so many allowances, A to I, it will be calculated, and if it exceeds half of the original DA and basic pay, that will also be added with the wages. So, we cannot escape from paying various type of allowances. Wage for payment of wages. For Equal Remuneration Act, this will be applicable. D, F, G and H. Now, a vast difference. Every Gratuity Act, PF Act or Industrial Dispute Act fix an employer a number of employees there. But this act says, the code says, no differentiation. The man who employs even a single man, he is an employer. So the employer definition is extended who employs one. Listen, every act at present fixes some minimum employees for getting that benefit. You know, EPF, ESI, Industrial Dispute Act. Industrial dispute, you must be a worker, otherwise you cannot use the Industrial Dispute Act. It cannot be adjudicated in labor court. If you are a non-worker, you cannot approach the labor court. Now this act says, employer means one or more employees in this establishment directly or through agency. The establishment run by central government, local authority, all are inclusive, no exemption. So here, so far many employers escape because the number is fixed in the law. Now there is no number at all. If you are having a business, even if you are employing one person, the labor code is applicable. Now contractors also, there is a different type of definition. Please listen to me, HR officers. So far we are having a recognized contractor, registered contractor. Now when you want to utilize the contract workers from a contractor, the procedure is, first you have to give a letter, an agreement. With that agreement, the fellow goes to the labor department, gets a license. While getting license, he gives the number of employees. Then he is recognized contractor. Only a recognized contractor can be employed in your organization. And here we are engaging the contractor under is a labor for quality or for work. See, we are closing our eyes. We are not bothered about who is working, because it's a contract for service. In a contract for service, there is a contract of service, contract for service. In a contract for service, we are engaging labor workers through a labor contractor, where the regular employee should not give any direct instruction to him. Only through the contractor you have to give instructions. Now this act says, any labor contractor who is having permanent workers with him, they are not called contract workers. They become regular worker for that organization. It's a great change now. Those workers supplied by a recognized contractor, they are recognized as a contracting workers, where you are having a work for service. Now there is a difference between contract of service, contract for service. Contract of service, I am engaging a man, I see qualification, experience, his antecedents, I know his work, then I am recruiting him. Now I am expecting his work to be given to my organization. I am not bothered about work. I hope that he will do work. This contract of service. Contract for service, I am not bothered about anybody. I am having 100 bags of cement here. It should be shifted to 1 kilometer away. I am giving a contract. I am not bothered how he is. I am putting some conditions how to be shifted. But I am not bothered who is going to take the bags. This contract for service. I am engaging this man as a clerk. I am expecting he will do the job. This is contract of service. Now, vast difference is, in a contract for service, if any contract worker is a permanent staff in that contract establishment, this code excludes. He is not a contract worker at all as per the code. If there are temporary casual workers under the contractor, they are defined as contracting workers. Now, very, very important thing I am telling you. If your organization is engaging an employee from a contractor who is not a licensee, for whom you have not given a letter, he has not got the license. The law says, the code says, automatically he becomes or she becomes the main principal employer's employee. Are you able to understand me? The moment you are employing any person from a contractor who is not having a license from the labor department, if there is an inspection and they are finding these people will be confirmed in your organization as a principal employer, because there is a Air India case where they engage so many contract workers, but the instructions were given by Air India officials. So here contract for service fails, contract of service wins. Instead of that company has to do only work, I am bothered. But all the Air India officers were giving instruction. So as a stroke of the pen, Supreme Court made confirmed employees for all Air India at that time. One of the reasons for closing for the loss of Air India is because of the judgment. So listen to me, from 1st April 2023, once it is notified, you should be very vigilant. You cannot employ any person as a contractor unless until he is having a valid license from the labor department. Two advantages there. One, you are getting a license and this fellow is giving supply. Two, if there is any contravention or if the fellow fails to pay the statutory benefits, as per the existing law, principal employer is binding. He is liable. But if he is a licensed employee, we can shift the liability to the government because, my dear friend, labor officer, joint commissioner, before giving a license, the labor contractor gave the list of employees. Though you know how many people are working in Ganga Hospital under a contractor. Then, if he is contravening, it is your duty to go and check because you are having the record. It is your maintenance duty. You have also failed. So, the principal employer can shift the liability to the government officials because he is a licensed contractor. See that exclusion, contract labor exclusion. Who is permanent employee of the contractor for any activity of the establishment, he is not a contracting worker now. Who gets periodical increment. Establishment means any place where any industry, trade, business, manufacture carried on and includes. Now this definition replaces the definition in the Industrial Dispute Act. Industrial Dispute Act says there must be business activity, there must be continuous activity. There are 4 ingredients for that. I have no time, but here the definition is very easy. Now, a very vast change, my dear friends, in the minimum wages. So far, Minimum Wages Act was implemented, fixed by the state only. So far, Tamil Nadu Minimum Wages Act, Karnataka Minimum Wages, Kerala Minimum Wages Act, all state governments enacted and implemented and fixed the minimum wages. Now, central government will fix a floor wage. Be familiar with the words. Floor wage. According to the geographical condition of India. So, they fix according to the locations. A minimum wage. Second condition, the state government can fix a minimum wage which is not less than the floor wage. So, suppose central government fixes a floor wage in Coimbatore, the Tamil Nadu state government has to fix a minimum wage over and above that only. So, floor wage will be fixed by the union government and minimum wages fixed by the state should be more than the floor wage. Floor wage, once in 5 years, they will appoint a committee and they will recommend. Fixation of floor wage. Central government shall fix floor wages looking into the minimum living condition. And there are many minute details about the cost of food, cost of cloth, cost of housing, etc. is calculated in every geographical area and they fix it. Different floor wage may be fixed as different geography. State cannot reduce the minimum wage. Fixed by floor wage, fixed by the union government. Mode of payment, we are following it. It can be credited by bank. Wage period, the same. There must be minimum, you have to pay the wages within 30 days. Deductions is very, very important now. There shall be no deductions from the wages of the employee except those now as on date. For certain reasons, for certain provisions, 75% of the wages can be deducted by the employer in the list of items. Now it has been reduced to 50% only. So an employer can reduce or deduct the wages only up to 50%. No 75%. Now in cooperative bank, etc., we can deduct 75% also, up to 70%. Fine, more or less the same. 3% of the salary can be imposed as a fine with a notice to the employee. And it should be collected within 90 days. Absence of duty, you cannot punish, you can cut the salary for those days in which he has not attended duty. Not more than that. Absence without notice, 8 days reduction. Here there are some institutions where employees come, they mark the attendance, they are going into the section, or workplace and they don't involve in working. அது தமிழ்ல உள்ளிருப்பு போராட்டம். Sit and strike. Now the labor code says even one day a group of more than 10 people are involved, you can cut 8 days salary. Removal of wage ceiling. Wage, there is no ceiling in respect of, because there was a ceiling, 25,000, 21,000 was ceiling for different types of law. Now it has been removed. Now, there are some employers, perhaps you don't know, they get an undertaking or from the employee in an affidavit form that as I know the employer finds very difficult, I am waiving my right of bonus, I am waiving the right of so and so and so, which the court says is illegal and it is punishable under this code. So all the undertaking or any agreement with an employee by the employer relinquishing his right become null and void. It is invalid. It is a very peculiar. See, before we got independence, when the British were ruling in India, there was a rule and they were following in a textile mill or any type of mill, a percentage can be paid in kind. And we abolished when we enacted Payment of Wages Act. The Payment of Wages Act says you cannot pay in kind. I don't know what is the reason and what is the wisdom. Now the Parliament enacted this code wherein you can see that 15% of the wage can be paid in kind. And I am yet to understand what for it has been fixed. We do not know. One day holiday for every worker, we are following it. Now third one, employee should not be made to work for more than 10 days. If there is an export company, I can get work from the worker continuously for 10 days. Then after that I can give 1 day leave. These are pro or favorable to the employers, inviting more funds from foreign countries. Termination, we are also following now. When we are terminating the employees under discipline action, etc., you have to pay the wages within 1 or 2 days of termination. This we already discussed. All the deductions, amenities, quarters, etc., whatever the charge you are going to deduct, you can get it, but you have to get the consent of the employee. Then only you can deduct. Please note the point, HR managers, you can deduct the salary, provided you get consent from the employees. If you want to deduct from accommodation or amenities, sometimes accommodation they charge money. Then under the amenities, you don't know, they charge a huge money. The law says you have to get consent from the employees. Now, this we are going to discuss about the advantage. In one way, sir, you don't know. At present, the employers are thrown from pillar to post. The advocates who are appearing for the employers also thrown from pillar to post. ESI, there is a separate court. For workmen, labor court. If there is a problem on wages, industrial tribunal. ESI court, there is a ESI court. EPF problem, EPF court. Then, Minimum Wages Act, Joint Labor Commissioner. Okay. All rules and regulations, standing orders, you want to recognition, you have to go to the Joint Commissioner. There are so many courts and tribunals. People are thrown from pillar to post. Now we put a full stop. Only one tribunal. And after 1st April 2023, if God willing, I don't know whether it will be implemented or not, whether all the states approve it because it's a concurrent subject. There will not be any labor court, industrial tribunal. In that place, the judicial member who is following certain rules and regulations in the labor court is to be removed, replaced by an officer. It is a tribunal, quick disposal. not like a labor court and court procedures, etc. And only one place for all disputes. So it is an invitation for all the employers and judicial persons, very easy to dispose. Now, Industrial Dispute Act, there are so many type of dispute, so many procedures, etc. It has been taken away. Tribunal is taken away. Industrial Tribunal is off. Labor Court is going to be abolished and replaced by another forum where only one forum is there for all the disputes. The minimum wages will be revised once in 5 years as per the code. Employer means, listen to me, employer means contractor also if he is having permanent staff. He is also an organization, he is also an employer. Sir, very easy now. No return, no hard copy. You have to upload all the returns in online. You need not go to the labor officer. You can simply upload all your materials in that. Inspection online only. If they are able to find out certain things, they can come. They will send a notice. The facilitator will come. The facilitator will come and ask you, why you are having so many employees and you uploaded only this document. With prior notice only he or she will come. If you are giving a reply, he or she can close that. Now, having uploaded all the particulars correctly, no labor officer or facilitator can find fault with you. So all web-based, no registers, no return. We are having so much of returns nowadays. Maybe 350 returns we have to pay, we have to send it to the labor court. No employer is doing. And if the labor officers are coming now, normally they will come for inspection, not for proper way. They will bombard you or ask all the questions you cannot answer. Then after that they will say, sir, this facility I want from the organization. If you are giving that facility, they will go off. Sir, there is a patient, sir, joint labor commissioners, wives, sisters, brother-in-law is admitted in your hospital. Could you kindly waive the bill? For that, he is asking and he is coming for inspection. This register, that register, this one, that one. No employer can do. But this web-based is abolished and we are so free. Sir, I will tell you, normally 352 returns we have to pay as an employer if you are having a factory or mill. Now it has been reduced to 5. That's enough. But you should be very sincere and you have to follow each and every step clearly and scrupulously. Then you can stand before anybody because they cannot put any blame on you because you have filed it. Nobody can deny it. Just like we had central government introduced passport system, etc. All are loading online. It is easy. So here also you can escape from them. Now his name is facilitator. I don't know how long he is going to be a facilitator, but at least namesake, inspector, labor, inspector of labor or labor inspector, etc. checking. Now no fear, he is a facilitator. Come and sit, take a coffee and go. No money business. No money. And appeal is also there in the tribunal. If an officer is demanding certain things, you can file an appeal because now the return is very less. One day I was a young fellow in 1970s, 80s. I was an administrator at that time. Personal HR was upgraded to personal management, industrial relation and labor welfare. 3 were now merged as HR. Previously it was personal management. I was a personal manager. Today inspection came, immediate inspection. And it's a car company. And they're sitting within 5 minutes, they have all the registers. Then after the 1 hour, we separated coffee for the inspectors. 2-3 people came. Not necessary, 3 people in the bound room. And slowly I went there. Sir, what is the purpose of inspection? They say, sir, joint commissioner's car came to your company with full diesel, but it was dried up in your company. And I inquired that and found that the car came with the empty tank only. They were recorded. And immediately I was summoned. I went to the joint commission office. Then I say, sir, I am a lawyer, I am working as a personal lawyer. Yes, sir. Okay. They bombarded certain questions. Then I gave a slip for 50 liters of diesel on the spot. And the dispute is over. This is the way we are functioning here also. And in any hospital, first of all, they will not reveal. Then only after that, they will reveal some patient is there. Why not we waive? Now, if you are working in an hospital, I will tell you, don't waive the patient's bill. I repeat, don't waive the patient's medical bill unless and until you get a letter from them asking for waiver. I repeat, don't waive any medical bill, whoever he may be or she may be, unless you get a letter from them that they are economically not able to pay. Please help us. Otherwise, 2-3 cases, the employer hospital failed because the fellow came and the bill was 8,500. He was crying and shouting in the medical superintendent office, even though it is not related to labor, I am telling you. And the medical superintendent, a nice fellow. They are more nice than other people. So he took the bill and waived it. After third month, and in between, he told me about this. I told him, don't do that. After 3 months, the same man came. He would start shouting. Invited medical superintendent, director, all the people, crowd. Bill is 85,000 now. He says it will be waived because you have done medical negligence. That word he knows. Medical negligence. Even doctor got medical negligence. Nurses are rude, shouting. Now the medical superintendent told him, yes, there may be medical negligence. You go to the court or send lawyer notice, we will reply it. Because before that I met him and asked him, don't do it unless until the fellow recognizes, sorry sir, I don't have any money, please. So because if you are waiving, the court presumes that there is a medical negligence. The trouble with us, we are so very kind. In CMC Vellore also, before I joined, the doctors will write 2 letters to the patient. Listen to me very carefully, it's HR. And they will try to explain, and the last letter, they are so Christian. Sorry for the regret, and we assure you best service in future. Please come to our hospital in future also, and we are waiving. You should not be so kind to a fellow who is not deserving it. Because if you waive, automatically it's presumed by the court that there is something wrong. Why you are waiving? No requisition letter. Why you are voluntarily waiving? Because you have done certain things wrong. So here, the record keeping is very, very important. Very, very important in all levels. There is a recent case in Karur, IVF. I was also representing one party. The police gave a number. This number patient, you bring all the files. The argument by the employer is, only once the lady came, you know the controversy, I don't want to go to the controversy. Less than 23 years, 16 years, they have taken the egg. So, when the officers are asking, hospital people without any knowledge, without any shrewdness, they produce 3 files about the same patient. 3 times she came, 3 times she gave the egg, which is completely unlawful. And in one of the documents, they fill up, sign on behalf of the employer, because the employer is elsewhere. And nobody is there. She herself signed in the witness column, 2 witness column. Consent letter, very famous hospital. I tell you, now the case is going on. According to this quality, they prescribed a consent letter, very good consent letter. In the last column, if the patient is not able to read English, there must be another person to translate and inform them and give a certificate. The fellow in the witness box says, Ayya, I was studying only 4th standard. Then, its signature, yes, I signed it. Do you know what is written? I don't know, yeah. Nobody explained. In the last column, translation column, empty. Court presumes that you have not explained what you are going to do with the employer, that patient. For example, I am telling you, the same way labor court also. When the labor court sends a petition filed by an employee, You should be very careful. It should be referred to the HR. In one case, the fellow was working as a veterinary assistant in a project. Listen to me. Veterinary assistant in a project, 2 years project. He filed the case in the labor court. In the filing, he says, I am a graduate clerk in CMC Vellore. Now, the HR and other people never denied that. Listen to me. They never denied that labor court case. It went against CMC. We filed the appeal before the High Court. The High Court says, sorry sir, I showed all the registers. There is no graduate clerk position at all in our office. Yes, we agree, but you should have denied in the labor court, which you failed. We can, as per the procedure, in the appeal, you cannot file any documents. Listen to me. In the appeal, any court, High Court or Supreme Court or any court, in the appeal procedure, you cannot bring in new witnesses, you cannot bring and mark any document at all. All should be done in the labor court. Labor court, the fellow was a veterinary assistant, studied only 10th standard. After that, by correspondence, he developed, he graduated by correspondence. In the labor court, he argued, I am a graduate clerk. HR was not referred. It was not denied. Automatically, presumption is, he is a graduate clerk. We accept. So, we should be very careful in dealing with what is the new code, HR? Sir, I have dealt code of wages. Very important. Now, I am going to conclude my talk. So, when I study 4 codes, you are HR. I am dealing only code, only wages. But I have studied all the 4 codes and I am going to explain about various new things in 4 codes also. 75% suspension of our employees only to up to 90 days only now. You cannot prolong. Within 90 days, you have to conduct the domestic inquiry, etc. and you have to pass a final order. Industrial tribunal to have 2 members. Now it is only 1 member. It is broadened to 2 members. Maybe non-judicial also. 1 from non-judicial. Now only judicial. So it is very difficult for the employers. He is a judge. He has been a judge. So he is always following the procedure which drags the case. Now they want to balance it with a non-judicial. Strike 60 days notice instead of 6 weeks. Now for strike 6 weeks, now it is being extended to 60 days. Labor court and board of inquiry and board of conciliation abolished. Fixed term, a very good bonanza for the employers. Here afterwards, any employee can be appointed on fixed term only, which is recognized, whereas as on date in Tamil Nadu, you cannot do it. In the new labor code, to enable the employers and invite more funds from foreign country, fixed term employment is introduced in the industrial relations code. So many employers started implementing it even though it is not notified now in Tamil Nadu. Some employers started testing this by giving 3 years, 2 years fixed employment. Overtime only with the consent of the worker. Now, listen to me. I told you, workers of unlicensed contractors shall be deemed to be employed by the principal employer. I told you, the moment you are employing unlicensed contractor employee, it will be deemed as though he is employed in your organization. Contractor license, not every year money has to be given. Now it is abolished once in 3 years. Accident death of an employee, 2 years imprisonment or 5 lakhs. So your employment environment is to be developed in such a way there is no death occurs. Minimum wage applicable to all employees. New paradigm. Engagement of contract rather than permanent fixed term contract. Section 25 FF is abolished. Section 25 FF is in the Industrial Food Act, where if an employee is permitted to work indefinitely for 5 years, 6 years, 7 years, when you want to stop them, you have to pay retrenchment benefit 50% of every year's service. That is now abolished because fixed term, you know the last date in the office before joining itself. You are given 2 years term. I know the last date itself where I will be working and I will be relieved. So I am informed of, put to notice. So no retrenchment benefit. Part-time employment is invited now, recognized. Now, employment can be made not in your organization, just like workers, many workers are not coming to the office. It is employment not in establishment. Platform workers are also covered now. Gig and Zomato, all the Swiggy, all employees are covered under the new labor code. Outsourced, emergence of gold collar. Gold collar means the experts who are sitting in their house and doing the job. They are employee, not attending the office. Pink color, almost in many establishments, women are dominating, which we call pink color. 2-member tribunal, less judicial, limitation of union activities. Listen to me. The union which is having more than 75% will be recognized as a union. Otherwise, they are called registered union. If you want recognition by the employer as a union, you must have 75% of the employees. You can ask the question, how we know that this union is having 75%? The law says, the subscription to be given by the worker to the union, listen to me, the subscription to be paid to the union will be routed through the employer. So in the salary scale, they will deduct this subscription to the union. Then as employer, I know how many fellows are paying subscription to this union. Thereby I know 75% or not. If they are not 75%, I need not invite them for any discussion. Limit. Gig workers. This is a very new thing which we discussed. A class of people who are trained in various type of employment. Nurse, okay, receptionist, she is also trained. She is also trained for emergency. She is also trained for casualty. So at any time, multiplicity of talents can be created. You had 40, 30 people. They can be posted for any department. This has been developed in some European countries, which we are following now. These gig workers, generic workers, they can be posted 3 or 4 areas. And now what happens is, once we are appointed as a clerk, in North India, I am a clerk. I will not do that. I am an ad. I will never touch it. I will not do it. This type of focus thing is demolished. This type of workers we can recruit. In the recruitment itself, we have to tell them, you are going to have multiplicity of responsibility. We will utilize your talent. And many workers are coming voluntarily because more pay and they are trained in 3 or 4 areas. This has been introduced only in hospitals only, not in any other area. Only hospitals, this has been trained. And online workers. Now, regarding the HR, I have written so many books. 2 books are very, very important. Laws on Hospital Administration, HR on Hospital, and Protection to Women, frequently asked questions, and a small write-up, maybe exclusively for the doctors. Legal provisions for a doctor at a glance. These books are available in the lunch hall. You can go and collect the book by paying the money, and you will get a receipt also for reimbursement. Now, before going as it's a HR, I will tell you, they have already discussed 3 things we have to follow. I have studied Gratuity Act. The Gratuity Act, in any act, before that they say main objective. Why they are bringing the law? So 3 things they discuss in the Gratuity Act. Number 1, every employee must be good. Good means 360-degree HR. He should be good to the superior, that is British period, colleagues and inferior. The man who is coming to clean your bathroom is also very, very valuable. And even if you are absent for 1 week, nobody cares. But the fellow is not coming, you cannot sit in your office. It is horizontal hierarchy, not vertical. Please understand. We have to respect each and every people. You will not believe, when I stepped my leg in the train in the morning, 5:30, I was amazed to receive a person there, deputed by this hospital. He is a driver to take me. He can stand in the parking area. Normally they will have a hoarding and they will stop there. But you won't believe, Mr. Stephen came to my compartment, invited me. Unbelievable. This is the way they should be good. We have to learn for each, everything, small things. See, perfection is not a small thing, but small things makes perfection. I repeat, my dear HR, small things, don't leave it. Small things makes perfection, but perfection is not a small thing. Second, you should be good. You should be efficient. You should good, it is not enough. You are very smiling, very friendly, very good, but work. The Graduate Act says an employee must be efficient. You have to develop your talents. Third is very, very important. Where we are lacking. Where we are lacking. Normally, these two we recognize. But third is faithful. You should be good. You should be efficient. You should be faithful. And the procedure says, even first two you can be tolerated. That fellow is not good. We can advise them, counsel them, make him happy. Second thing, you can train them to make efficient. But third, faithful, he cannot be kept in our organization. He should be sent. Because faithfulness is very important. And faithfulness is confused at present because, sir, why not I resign and go to another company when I am getting more money? I am telling you, you should be faithful to the organization as long as you are working. Wife is not good, I adjust. She is very bad in cooking. Doesn't matter. It becomes a life. I can tolerate. She is not good, always fighting. Okay, I become a buffalo. Because bond is very important. But my dear friends, you will accept that. The moment she is not faithful, you all join to me and send her away. Because you cannot keep a person who is not faithful. First two tolerate. Employee also, we have to find, there are so many tests to find. And I am going to close with an example. Now I am going to leave. In 2008, Taj Palace was encircled by the extremists. 3 days besieged. There are 350 employees. Listen to me very carefully. This is very important, not the code. Code on wages is not important. And they start shooting. The employees knows various type of doors to go out, escape. 365 employees, you can see in the Googles. They never tried to escape. Please believe me, it is a fact. They never escaped. One lady, telephone operator, she escaped. After crossing 10 feet, she returned back. Oh, I know the English. The extremist does not know the English. I have to caution all the guests. So I must be there. She returned back in a secret way and she started working. Believe me, it's a fact. Nobody escaped to save their life. And the general manager, Mr. Gang, he is from Punjab, having a young, beautiful wife, 2 children, living in the 5th floor. They were shot down by the extremists. And the general manager was in the floor, having a barricade, preventing all the guests not to be shot down by the extremists. Minimum casualty, the extremists want to kill only not the Indians, only the foreigners. And instructions were given to the guests, please go under your cot, under the pillow, under the bathroom, lock your room, etc. The instructions were given quickly. And more than 300-400 people were celebrating some celebration on that day. They became also employees and they were trying to help the employees. Listen to me, some employees died. Third day, after the police came, then only the employees came out. And this was publicized. Harvard University took note of. That is HR. That is HR. Harvard University professor heard this. He came with the team. He interviewed every people there and the affected people, those who are working, etc. What made you not to flee from the place where your life is at stake? And you can understand, I am leaving it to your imagination. There are some facts, it will take more time. It is published in the Harvard University. You can go and search that. You can read. They have given reasons for that. I don't want to do. But you can imagine how faithful they would be to stay 3 days there without food or anything, protect the lives of the guest. Same feeling HR and other people must have in the hospital scenario where you are not a HR manager only, you are not a person manager, you are not a lawyer. No, no, no. We have to do all sort of things. In that area, in that time, there's no designation in Taj Palace. Everybody done their own work and various type of rules to save the ultimately they save the life of guest, and guests are their God. Thank you so much.
Thank you, sir. It was a great, great talk.